come before the court is Clayton Ausmundson v. Jennifer Spicher, is that correct?
Yes, that's correct.
Each party, well, in this case, you will have 15 minutes to present your argument. The arguments are being recorded, so please keep your voices up and stay behind the podium. Introduce yourself. You should not use the names of children or minors. You can use initials or terms like the child or the children.
Won't be a problem.
The judges have read your brief and we're ready to proceed when you are.
Good morning. May it please the court, my name is Joe Oliver. I'm here on behalf of the plaintiff appellant Clayton Ausmundson. I do not need 15 minutes, I think, to present this case. It's a pretty simple, straightforward case. The plaintiff brought a complaint to a evicted tenant on the basis of the tenant having held over a 6-month term lease. It was not a month-to-month lease. The magistrate denied the writ because the magistrate said that there was a 30-day notice to terminate that was required. By quote from the magistrate, she said, even if the lease is ended, you have to provide a 30-day notice that you are not going to renew that lease. And that's in the transcript, page 2. That is clearly a misstatement of the law. That is not the case. I've cited a number of cases in my brief that establishes that that is not the case. I filed an objection to the magistrate's decision on the basis of the facts and the law. I supported that objection with a transcript that I had prepared in my office. That the recording, or rather the hearing, was not attended by a court reporter. It was rather recorded. I got the recording from the court. I had it typed up. I had it sworn to by a notary, and it is, the notary swears that it's an accurate, complete transcript of the hearing that occurred in this case. And the court denied the objection, saying that there was not, that the plaintiff had not requested or paid for or provided a quote-unquote official transcript. Now, the term official transcript is not a term that appears anywhere in Civil Rule 53, which governs objections to magistrates' decisions. So the court, in effect, created a new requirement, a requirement not found in the law, that the plaintiff provide an official transcript, whatever that is, and then request it, and then he paid for it. And that it be requested and paid for is also not a requirement in the law. So basically, by creating arbitrary conditions to filing an objection in the trial court, conditions that are not provided for in the law, the trial court denied the plaintiff his constitutional right to due process of law.
Did the Akron local rules of court have any requirements regarding preparation of transcripts?
They do not. I could find no rule anywhere that has a requirement regarding transcripts that apply to this case. I did cite in my case that the Court of Appeals here has a rule regarding transcripts.
What about Local Rule 26? Are you familiar with that?
Akron Community Court, Local Rule 26?
You know what, if it wasn't in your brief, it's okay.
Yeah, well, I have scoured the rules. I saw no rule in Akron Community Court that applied to that situation, to this situation.
Okay, very good.
Okay, so now they've denied the objection on the grounds that there is no official transcript, whatever that means. And they just dismissed the whole case and affirmed the magistrate. But they never considered the legal argument that was made. And the case law is quite clear that when a transcript says, when a party objects to a finding of fact and fails to support the objection as required by the rule, the trial court may accept the magistrate's findings of fact, but must still review the conclusions of law that are subject of the objection. And this is from Tillman v. Hyde Parker, which is Summit County Court of Appeals case decided in 2013. So I think that we've got a clear error here, and that the court failed to consider the legal argument. And the case law that I cite to you in the brief makes it quite clear that there is no requirement that there be given a 30-day notice when a lease has already been terminated. All that's required is a 3-day notice.
If we're not looking at the transcript from if we were to rule against you on the transcript issue and say, trial court correctly decided you didn't follow the transcript rules appropriately, I think you would say you still have to make sure the trial court did its job and reviewed the law to make the legal decision was correct.
That's correct.
Is there enough of the decision in the decision
magistrate's ruling that specifies that there has to be a 30-day notice in order to terminate the lease. I mean, we've got a complaint in this case that is based only on a hold'em. There's no claim in the complaint that there was a breach of the lease as grounds for the eviction. And then you've got an eviction or a magistrate's decision that says that in those circumstances you have to give a 30-day notice, and that simply isn't correct. So, I mean, there was a claim of breach in support of count 2 to collect money damages, but not in support of count 1 for eviction. I have nothing further if the court is.
Any questions? Okay, hearing none, we thank you very much. The court will take the matter under advisement, issue a decision in due course. We will mail a copy, well, the clerk of courts will mail a copy of that decision to you on the day that it